Hello, everybody. Welcome to our webinar. My name is Blake Gerney. I'm a member at Brennan Mannett and Diamond. We've got a lot of information to go through with you today about some coming legislation. I have with me today Jake Davis. Jake, why don't you say hello to everybody?
Hey, good morning.
Jake's a lawyer in our firm. He's in our corporate and business practice group, and he works with me regularly on handling these kinds of issues for our clients. So some of the materials today I'm going to present, and then he's going to be presenting as well. We've allotted a half an hour for this. We want to be respectful of everybody's time. So we're not going to be taking a huge deep dive into lots of the details. This is intended as a nuts and bolts webinar, just to kind of give you an idea of what's coming and and whether or not businesses that you're associated with may or may not be impacted by it. As I said, it's a half an hour. We're going to go through the materials that we have, but we can stay, Jake and I mean, if there's lots of questions and a lot of interest, we can stick around a bit afterwards and try to answer those. I know there's the chat function. You can feel free to use that, although I think we'll probably be waiting until the end to address those questions, just because we want to be able to fit everything into the half an hour time frame. This is like so many things in the law. We could talk for a day about it, or we could really whip through it really fast and be done in 5 minutes. So hopefully we'll land somewhere in that half an hour time frame. So with that, let's just jump right into this. The things that are coming down the pike, this beneficial ownership information reporting rule. Actually, Jake, go back for just a moment. I'm sorry. What I wanted to say is we're going to go through, and I apologize. I also want to mention that the way that we're going to do this is I'm going to give an overview of a lot of the specifics, nuts and bolts items that everyone needs to be aware of. Reporting entities, that's a category of the types of businesses that need to report. I'm going to let Jake handle that. Then there's, of course, the next question is, if you have to report, who within your organization needs to file this information. And then back at the end, the company applicants, that's another category of individuals that will need to be reported, and I'll cover that. And then, as I said, we'll handle the Q&A. So I'm sorry, Jake, you can flip over to the next side and we'll get going. So as I started to say, the beneficial ownership information reporting rule, it comes from the Corporate Transparency Act. That was a law passed by Congress on a bipartisan basis and signed into law back in 2021. I mentioned the bipartisan basis because so few things, it seems, these days are adopted by both parties and pass with that kind of consensus. But that happened here because everybody believes and understands that the issues that they're dealing with here are very important, and want to make sure that our society handles them in the appropriate way. The rule was adopted in September of 2022. There's been public comments back and forth. There's still some of that going on. Some of the information is still coming out from the Department of the Treasury. And what the rule generally says is it defines who must file this information, and what information must be provided, and when and under what circumstances it has to be provided. That's just a general statement as to what this is all about. And beneficial ownership information is personal information about those individuals who directly or indirectly own or control a company. So there's a couple parts there. I mean, directly or indirectly, they're talking about people that influence or have a direct ownership, maybe stocks, units in an LLC. But it's beyond that. They're also looking for people who may control a company. So even those individuals who aren't owners may be impacted depending upon their relationship to the company. For example, a chief financial officer, people of that nature that may not be owners, they may be roped in, and Jake's going to cover that in a little more detail as we get through that. But that's what we're talking about. Now, the purpose of this rule, it's part of our government's efforts to make it harder for bad actors to hide or benefit from money laundering or tax fraud, financing of terrorism, and the utilization of small entities, opaque entity structures that are filed in the United States. So, for example, I have clients all the time where I form the LLC for them. There's no public filing with the Secretary of State's office that indicates that they're connected to the company in any way. And so, as you can imagine, bad actors may take advantage of that anonymity and create multiple companies that are owned by other companies that are themselves owned by other companies. And so the law is designed to attack that and to allow the government to understand who the actual owners are of these entities. The rule is it's being administered by the Financial Crimes Enforcement Network. We call that FinCEN. That's not my term. That's just what everybody refers to it as. And that's a department within the U.S. Department of the Treasury. And FinCEN is empowered by the Corporate Transparency Act to collect this beneficial ownership information from companies that are required to file and to maintain a database that has all of this information available. Now, available to whom? Well, as I mentioned, it's designed to stop the bad actors out there. So it's intended to be made available for national security purposes, intelligence, and law enforcement. So Homeland Security, FBI, CIA, some foreign officials, depending upon the relationship or the need for the information, they may be provided access to this. And so the next logical question that arises, those are the purposes behind it. The next question that many people ask, and I've had a lot of clients ask, is, gee, Blake, they're going to collect all this personal information. Where's it going? Well, and will it be protected? I'm concerned about confidentiality. And well, the Department of the Treasury has not specifically indicated exactly how everything will be maintained, but I'll read to you real quickly what they say. They said that the beneficial owner information that will be reported and stored, it's going to be held in a secure, non-public database using rigorous information security methods and controls typically used in the federal government to protect non-classified yet sensitive information systems at the highest security level. That's way above my pay grade. I don't know exactly what that means, but the intent, I think, is that they're going to lock this information down and only make it available to those individuals, as I mentioned, in law enforcement, and the use by those individuals has to be for authorized purposes. And when it's disclosed to, say, the FBI, they're supposed to handle the information in a way that maintains its confidentiality and the high security levels. So that's a confidentiality issue. The next question that I get a lot, and one of the nuts and bolts that I want to cover, is when do people have to report? Well, as I mentioned, the law was passed in 2021. The rule was adopted in 2022, but it doesn't go into effect until January 1, a few weeks from now, January 1 of 2024. And at that time, the online filing system that will be administered through the Financial Crimes Enforcement Network, FinCEN, as I mentioned, that will go online. But whether or not a particular company that is required to file has to do so then is dependent upon a couple of factors. So existing companies that are in existence on January 1 of 2024, they will have a 1-year time frame to determine if they need to file, who in their organization needs to provide this information, so they've got a 1-year time frame to get that done. For all entities that are created after January 1 of 2024, the original rule indicated that those entities would have a 30-day time frame within which to file the information, the appropriate information, if needed, with FinCEN. Now, just a week ago, the time frame was amended and was approved that in the initial year, so next year, any entities that are created at that point in time, any businesses, LLCs, corporations, for example, they will have a 90-day period in that first year to go ahead and file. So they've increased that 30 days to 90 for that first year, and that makes some sense. The comments were, the public has to get used to, and practitioners like myself, well, we all have to get used to this, and they want to give you a little bit of break in that initial year. So that's the time frame. So again, if you're in existence on January 1 of 2024, If you do have to file, you have a 1-year time frame to get it done. Anything created after 2024, beginning of 2024, has 90 days, and then moving into 2025, all entities going forward will have the 30-day window. But it's not done there. That's just the initial reports. The rule, and what I think, frankly, is going to be the part of the rule that can trip people up, and might be something that that is a little more problematic, is the ongoing reporting requirements. And I'll just go through that really quickly. If you don't file an initial report, say you're in existence right now and you have until the end of 2024 to file your initial report. If you determine that you don't need to file because you fit into an exemption, and you don't file, but then something changes somewhere down the road, whether it's in 2025, 26, whenever, and now you are no longer exempt, you have 30 days to file your report. And I can see this falling off people's radar screens, and all of a sudden realizing that they're not exempt any longer, and maybe having already missed that deadline. Here's another ongoing factor, is if you do file in 2024 because you are not exempt, but then something happens in the organization in the following years that causes you to be exempt, you again have a 30-day window to update the records and tell the government that, hey, we're no longer required to file, so we're just letting you know that we're no longer filing. Seems kind of crazy, but it would relieve any obligations of correcting information down the road. So again, that's a 30-day window. If you file an inaccurate report at any time, and then you become aware that, hey, I put the wrong address in for these individuals, you have 30 days to correct that error. If you file a report and at the time that you filed, it's perfect, everything is correct, and then all of a sudden, some of the information changes. For example, I use the address. If you move to a different house and you're no longer where you were before, you have 30 days to update the federal government through FinCEN that the information on that initial report has changed and you need to update it. So those are pretty tight timeframes, and I can see where business owners and individuals like myself, until you get used to these rules, we're going to need to be making sure that we're moving forward, and cataloging and keeping this on the top of our minds so that we don't miss these deadlines in the event that they come about. Next section is, what is it that we have to report? As I mentioned before, it's beneficial owner information. And what is that? Well, for the company, it's pretty simple. It would be the full legal name of the company, any DBAs that it operates under, where it was formed. So if it was an Ohio LLC, that would be the jurisdiction. You indicate Ohio. They want the complete current addresses of the principal place of business. No PO boxes or third-party agents required here. They want to know where you're doing business from. They want to know the employer identification number, again, tax identification number of the business. And then if you have beneficial owners of the business, for those individuals, you're going to have to indicate date of birth, full legal name, residence address. You're going to have to indicate a driver's license number, passport number, state ID number, and then you're going to have to upload images of those documents to FinCEN as part of the reporting requirement. There are some individuals, obviously, and some reporting companies that may or may not be exempt, and there are some categories of exemptions. For example, one company owning another company, if one is exempt, depending on how that ownership structure is, you may end up being exempt and not have to file this information. One of the things also that might make it, you can imagine if somebody, I know myself, I have clients that have, a dozen or more LLCs for a variety of reasons, and they may all need to file. It might be cumbersome to have to indicate the same information report after report. So FinCEN has authorized what's called a FinCEN identifier, and that is simply, sort of you indicate the information once, you'd get an identifier through FinCEN, and anytime you were required to report, say yourself, again, you can just indicate the identifier and not have to go through all of the variety of information that they're going to want to collect. Really quickly, there are penalties to this. The rule provides for civil and criminal penalties for violations, which include a fine up to $10,000, imprisonment for up to 2 years, or both. For persons who willfully provide or attempt to provide false information, they fail to provide complete or up. And the trap here, or the potential trap, would be, people that are responsible for, or senior officers in an entity that is not exempt, that is required to file. Their failure to do so, they may be held accountable. Now, there are some safe harbors about the timing of things, and I can't imagine that FinCEN is going to be right out of the gate super aggressive. They recognize that it's going to take some time for the public to be used to and appreciative of this. But if there's a deliberate or willful disregard and you continue to not file when you were supposed to, I can see them, there are going to be people out there that get themselves in trouble and might be subject to some of these fines and penalties. So with that, that's the quick overview, although it was a little not as quick as I thought. There was a lot more that I could get into, but I'm going to flip it over to Jake now and let him talk about reporting companies and what types of companies need to report.
Yeah, thanks, Blake. And just generally, we go through this big overview, and now we're really into the analysis here. So this is going to be a case-by-case approach, also for a reporting company as well as beneficial owners. So it's just important to know there are decision trees and plenty of factors that are going to be relevant here. So I guess the first big important point is, these required reporting entities. What are they? When will you be required to report for an entity? And like Blake did, we have quotes from what FinCEN's provided, but we're going to see how that goes in practice. So FinCEN provides that all domestic and foreign entities that are within the scope of the definition of a reporting company must apply. So reporting companies can be domestic or they can be foreign. So a domestic reporting company is a corporation, an LLC, any other entity type that has been created by making a filing with a state secretary of state. So that's an Ohio LLC, a New York corporation, anything where you have your articles of organization, articles of incorporation, that's going to trigger you under this domestic reporting company. A foreign reporting company would be a non-U.S. entity that fits into those same categories, a corporation, LLC, any other maybe limited partnership that's formed under the laws of a foreign country and is registered to do business in the U.S. So we'll encounter this sometimes with, say, a Canadian LLC that's registered in New York to do business just because of the close boundary. That entity is going to be subject, just as the Ohio LLC, to these reporting requirements. And the key note here is, and there are definitely some exceptions, but FinCEN's kind of bright line here, for lack of a better term, is if you're filing something to form your entity, more likely than not, you're a reporting company. So that might not include a general partnership. It probably doesn't include sole proprietorships. But the issues then are getting into more state law questions, which will definitely require case-by-case analysis. And the real, billboard topic here is, well, what entities are reporting companies but find themselves exempt from the reporting requirements? And this is a rather verbose topic, of course, as you can imagine. There's 23 enumerated exceptions right now. But in preparing this presentation, Blake and I identified the 5 there that you see on your screen as really the most relevant for a small business that's, not in the banking industry or being regulated by the SEC. So just off the bat, each of these 5 have very specific prongs to trigger, but we thought it'd be beneficial to just kind of pop through them quick and just kind of get them on your radar. So the first you see there is highly regulated entities. So this encompasses many of those individual enumerated categories. And just kind of some examples here. If you're a public company, registered with the New York Stock Exchange, you're going to be exempt. Venture capital firm, insurance companies, and generally entities in the banking industry. So credit unions, banks, venture capital, all those sorts of financial industries are going to be removed. The thinking being, they're already beholden to specific reporting requirements for their industry, so they're not going to add this on to that. The second general category is inactive entities. So if you're in existence on or before January 1st, 2020, but you're not engaging in active business and you meet another 4-part test, you won't have to make any of these reporting information available. And the third category is a tax exempt entity. So these are entities that have their tax exempt status under the Internal Revenue Code section 501A. So it will include most tax exempt entities that have an active 501c designation. So, generally you hear the 501c3, those sorts of entities are not going to have to comply. The third category here is these large companies. And it's kind of counterintuitive because FinCEN tells you what a large company is, even though you might think your LLC is large. There are very specific points here. So the first being you must have 20 full-time employees in the United States. The second is you must have a physical operating presence in the United States. So for many companies, that means you have a headquarters in Cleveland, Ohio that you're operating out of. You'd meet that prong. And the third one is you must have 5 million in gross receipts on sales on your previous year's tax return. So this is one that, as Blake just mentioned, you could be exempt under this exemption for 2025. But if your gross receipts dip below that $5 million number, you're no longer exempt under this exemption. You'd have to go through all the hoops and make your information reported. That last one there is subsidiaries of exempt parent entities. So this would be, in that example Blake said, many of our clients have numerous LLCs. A lot of times there's a top line LLC that then owns down the ownership chart. If you can show that the top LLC is exempt, those below it would also be exempt, so you wouldn't have to report there.
Jake?
Yeah, go ahead, Blake.
I don't know. I didn't want to cut you off there, but I do want to add, because Jake mentioned the word counterintuitive. I know that our clients are used, when regulations are imposed by the state or federal government, our clients are used to saying things like, well, I'm a small company. I'm not, all I own is an LLC that owns owns a piece of real estate. I don't need to report because I'm under the radar. I'm too small. But you have to understand this rule is different. This rule is designed to hit those small ones. It's designed to force those small businesses that typically don't report any information anywhere except by filing maybe a tax return and filing a couple of pieces of paper with the Secretary of State's office from time to time. It's designed to force those small entities. That's why it's a small business ownership information rule. It's designed to force them to disclose this information so that law enforcement can utilize it. So you have to flip your thinking. Most of my clients, like I said, are used to, I don't have to comply with the Family Medical Leave Act. I don't have 50 employees. I'm under that. So, I mean, but this is the opposite. So I'm sorry, Jake, I didn't want to enter, but that's an important takeaway that I want everybody to hopefully remember when we're done here.
Absolutely. Thanks, Blake. So then, we've maybe identified, okay, my entity is a reporting company. I'm going to have to produce all this information. The next step is going to be, who is these people that must show up on my application with FinCEN? And we get this another defined term that they really hammer, that if you have to make sure you meet these tests. So you'll see there, the term that they use is a beneficial owner. And then again, on the topic of counterintuitiveness, this is another example. You can be deemed a beneficial owner in two general circumstances. The first, meeting an ownership threshold, which we all could understand. And FinCEN defines that as you have a 25% ownership interest in the company. So that could be, 25% or more of the membership interest if it's an LLC, 25% or more of the issued shares if it's a corporation. If you meet that threshold for ownership, you're going to be one of those names with all the information that's required to be reported. The second example of a beneficial owner, and this is something that's going to be very important for all business owners to understand, is those that exercise this substantial control over the LLC. So a lot of times we'll encounter clients that form an LLC. The operating agreement sets forth, we have a president, a vice president, secretary, treasurer, but maybe none of the owners are listed as those officers. And the hope is that I love this business, I'm passionate about it, I put the money in, but I'm going to be hands off and let these 4 individuals that I trust run the show. Sure, you would have to report yourself as the owner because you're the one that has all that ownership interest. But the people that are exercising the control over the company are treated just the same. And this is, again, going to be an instance where you're going to really need to consult with someone to tell you, does this individual meet the test? Just some high point topics here that we encounter often with our clients in dictating responsibilities. Some of the circumstances define substantial control. One, and this is an easy one, is, serving as a senior officer, the president, CFO, general counsel, CEO, those sorts of topics. The counterintuitive element under that point, though, is when is a senior officer truly a senior officer? And the analysis there is rooted in exercising authority or performing similar function as one holding a senior officer position. So even if you don't call your CEO the CEO, if the duties look the same, they have to be included on your report. Another big one is any individual that directs, determines, or has substantial influence over important decisions made by the reporting company. So that's another kind of gray area there. Well, what's an important decision? FinCEN does provide some options, but we can definitely see an instance where, there's a pretty big decision that's made. It doesn't show up there. It's important to know, okay, this does meet or this doesn't meet. So some general examples are, having control over major expenditures, approving an operating budget, having the ability to amend governing documents, and the ability to enter into or terminate any significant contracts for the entity. So again, that's a lot of information, but there's another prong here that's important as well. You could still be considered a beneficial owner of a reporting company, but be determined to be an exempt individual. And you'll see the general categories of those exempt individuals on the screen there. Generally minors, nominees, certain employees, heirs, and creditors. And just in the interest of time, we'll hit on a couple of them here that might be very relevant to your entity. So that third one, there are certain employees. These are employees that are not senior officers. So it's not your CEO or your CFO. They're acting solely in the capacity as an employee. So they're not an owner in any way to determine that. But they do derive significant substantial control over the company. So an example here would be a mom and pop grocery store that's an LLC. The grocery store has hired a store manager that is paid, an hourly rate that runs the day-to-day operations. Just because they can determine, who the cashiers are, fire staff, they're operating solely in an employment capacity there. That's an exempt individual. And that last category that's going to be very relevant too is creditors of the LLC. So a lot of times you'll see, you enter a loan agreement, there's an underlying balance you owe to that individual, and they have the right where if you default on that payment, they could call into question your ownership interest overnight. Just by the sheer fact that you owe someone money, that does not make them a beneficial owner in your LLC. So again, and you might be getting there as we've gone through a lot of this analysis, and I got to meet one test and another test and another test. The best advice we can give you is to seek legal counsel, because while there are definitions and there are categories under each definition, we're really lacking bright line standards for a regulation that's going to be as new as this one. So Blake, I'll turn it back over to you for company applicants.
Okay, thank you, Jake. We're right at the 12:30 mark. I'm going to very quickly go through company applicants. This is another category of individuals that would be required to be listed on your report should your company be one that needs to report. And this isn't that complicated, but it's only applicable to entities that are created after January 1 of 2024. So if you're an existing company and you have to file a report, you don't need to worry about company applicants. So, but a new company that is filed, say, anytime after January 1 is going to have to comply with this. And what this is about is, again, FinCEN, federal government wants to know who's involved in the organizing, running, making decisions in businesses. And so the company applicant category is they want to know who assisted in forming this entity. So there are really two categories. The direct filer. So if you're the person who actually filed the paperwork with the Secretary of State's office in Ohio, corporations and LLCs are formed by filing, as most people know, with the Secretary of State. If you're the one that actually files the document, then you would need to be listed on the beneficial owner information report. The also is a situation where if you were directing the filing of that document, the formation document, if you're the one that directed the control and you had somebody else do it for you, both of you would need to be filed. So the direct filer and the one who's controlling would have to be listed, and their beneficial, their ownership information or their personal information would need to be included in the report. It's interesting to me, they say in the regs that there's only ever going to be two people that would be listed here. And I know I can see a scenario where, a couple of people are involved in directing the filing and one person does the filing. So I'm not quite sure how that'll play out. We'll have to see. Most that comes to mind is law firms. We form these entities for people all the time. I don't do the direct filing often. I have my paralegal do it, but she's working under my direction. And so in that instance, I would need to be listed as a company applicant, as would my paralegal. And there's any number of other scenarios that you could come up with, because not everybody forms their entities through lawyers, where this might be necessary. So that's the materials really for that we have prepared. We want to be able to answer some questions. Jake, I'm technically challenged. Do we have any questions that have come through the chat function?
I will divert to Sarah there. I'm not seeing the same.
We do have one question, and they ask, are churches exempt if they do not have a tax exempt letter?
That's interesting. There are one of the requirements is that you are officially recognized as a tax exempt entity. And what many people may not understand is that, they use the word nonprofit all the time. Ohio, like every other state, has a nonprofit law. So you can form your corporation as a nonprofit entity. But if you want to be tax exempt, just because you're a nonprofit entity doesn't make you a tax exempt entity. You have to then file the appropriate paperwork with the Internal Revenue Service to see if you qualify as a 501c3 for religious, educational, charitable purposes. Obviously, a church would be a religious exemption. If you haven't filed and they do not have a recognized tax exempt status from the IRS, my gut reaction to that is that you are not exempt and you will have to file. Again, I will add this though. I think that's the way that it would shake out. But these are fluid rules. I don't know if everybody remembers not that long ago when we had the PPP loans. If you're a business owner, you certainly knew about that when the pandemic was hitting under the CARES Act. And I mean, it was almost daily as the law was being rolled out. We were getting updates, and what we thought we knew and we thought was correct turned out that wasn't. I don't think it's going to be quite that crazy for this beneficial ownership information rule. But you never know. We're going to have to be monitoring this in the early days, because my gut is, and just from experience, is that things don't always roll out as smoothly as they want. And so we'll have to be mindful of updates. But I think as written right now, the rule would require an entity that, even though they're acting as a church, if they don't have their tax exempt status and their IRS determination letter stating that, then they would have to file. Anything else, Sarah? Or we?
There's one more question. Will company applicants be issued an identifier?
No, they won't be issued. Not to my knowledge, they're not. At this point in time, company applicants, there may, a lot of times if you're not going to an attorney, for example, to form your entity, they will have, the person who files it could be the owner. So they would have to already file as an owner. They would just have to list themselves in the same information. But I do not believe as of right now that the regs have company applicants getting FinCEN identifiers. They do allow that for individuals who are beneficial owners, and also for the companies themselves. And when those FinCEN identifiers can be used, it just depends upon the circumstances. And that goes back to what Jake was saying is, you have to, every situation for each business might be different. And so you need to speak to somebody to make sure that how these rules will actually apply to you. And, we're available to assist with that. Obviously, we're in business. This is what we do to help our clients and any others. We have just determined, for that many people just don't know whether they need to. So for a $225 flat fee is what we've come up with. We'll spend a half an hour with anybody who needs to take a much deeper dive with respect to their entities, and we'll determine what needs to be done. Obviously, every situation is different. So from that, it may or may not be that there's additional information that is necessary. For example, I will just point this out is, if you're a multiple member LLC, so you've got 2, 3, 4, 5 owners, that each of those owners may have to give their personal information. The company may have to do it. We're advising all of our clients in those circumstances that we need to update their operating agreements to reflect these new rules, and that if one of the owners or beneficial owners don't do what is required or refuses to, or through their negligence, the company is impacted and maybe is hit with penalties, that there's reimbursement and indemnification provisions and all the other things that go along with that. And so we're recommending that to our corporate clients and to our LLC clients, that they give them some thought to that. However, every situation is different. So we need to, until we have a chance through that initial consultation and analysis with the client to be able to determine what might be recommended or necessary. It may be that there's nothing after we go through it, but until that happens, we just can't advise them. But those are the things to think about, and the things that I'd like everybody to hopefully take away from this.
And Blake, they're asking if the forms are available yet.
A great question. I'm glad you said that. In our haste to try to fit this into a half an hour, they are not available yet. We ran through some of the information. I talked about uploading images of your passport, perhaps, or your driver's license. We know the categories of information. It's going to be an online filing. I don't know what the form is going to look like. I know that the public comments closed at the end of October, I believe. But FinCEN has not come out with what the form will look like. I mean, and we're already at the 7th of December, and we've only got a few weeks. I could easily see, we're getting right down to the wire, and it's, you log on January 1. But remember, if you're an existing entity, you have until the end of 2024 to get your filing done. So you don't have to run on January 1 and do it. I don't suggest necessarily waiting unless there's a reason to do so. Some of my clients may be close to an exemption. They may fit. They might want to see how 2024 plays out, because depending on, Jake mentioned the large company exemption, you may want to wait and see before you file. So again, that's all part of the analysis that I think every business owner is going to have to go through. But we don't know the forms yet. I'd love to see them. I looked today, and they're still not published.
And we have no more questions.
All right. Well, everybody, you can see Jake and we've got our emails on the screen. I know that we will be making this available in a video. Sarah, is that correct? We'll be able to send links to all the participants.
Yep, that's correct. We'll send an email with a link to the video.
Wonderful. And so if you have any questions, you feel free to contact Jake or I about them. We'd be happy to help you and any of your professionals watching this, any of your clients. And I appreciate your time, and we thank you for participating. Have a great day.
Yeah, thanks so much.